Carrie Sykes versus Donna Allen.
Thank you, Your Honor. Austin Church, appearing on behalf of the plaintiff, Carrie Sykes.
And I've got Miss Allen,
This is
you're on
Donna
there.
Allen.
All right, you're on there. Looks like this came back to me. We entered a default, I guess, at one point. It was set aside. I guess that's where we're at. Mr. Church, did you?
Yeah. So,
Well, I'm sorry, man.
yes, this was arising out of the 7th District Court, and so they set it aside yesterday.
Uh-huh. Yep, I got their order
So,
saying I need to hear it. So I got that in front of me. Um, and ma'am, I know we talked about this a few times. It's the only reason I, quite frankly, took the default. It's been adjourned several times, and yet apparently issues, whatever it was last week. Were you here? Is that what it was?
yes, it
January
was for
12th.
landlord.
Okay. Did you? And if I remember right, you talked to legal services. Is that right?
No, legal services, because the other people had legal services, they denied me. So the eviction landlord, because I'm the owner, one of the owners of the property, the owners had a lawsuit and the judge set that aside. So I was either dismissing a eviction notice from the plaintiffs.
No, I'm confused. Mr. Church,
Judge, I can give you
help me?
so let me give you a
Okay.
brief history because this, and I will say this is going to get a little bit confusing. So the history on this is there's a civil case. It started as a partition case against Miss Allen in Seventh Circuit Court in front of Judge Hannibal. My client, we were able to obtain a default. That default sat for about a year and a half. Unfortunately, yesterday, so what happened was Miss Allen had filed a motion to set aside that default in circuit court. Essentially due to a clerical error. We had simultaneous hearings at 1:30, and we were not, because of, I think, a miscommunication with the court, we did not appear on that. And the judge went ahead and heard it, and since we were not there, I'm assuming just granted that motion to set aside. But all the judge set aside was a default. My client is still the owner of record of this property, and I think that Miss Allen should have to show good cause and a meritorious defense to set aside the default for not appearing in the landlord-tenant case. Because in my understanding, the last time we were here, she did not appear on, I believe it was January 20th, 2026.
Okay, boy, now that I look at that, I got you. This isn't really the one we had. This is with all the other parties. George Colson, George Grundy, Carolyn Grundy. She just brought it in, I guess, and stuck it in my file. That's kind of what we got. That sound right.
That does sound right, Judge.
All right. So I haven't made a mistake yet. So that's pretty good. So let's just stick with that. Hopefully it goes. And ma'am, are you can't hear me? Oh boy, I got Miss Allen apparently is out here. You can't hear me on there? Okay, you know what? If you don't mind, Mr. Schutz, I'm going to get her up on her monitor. I don't usually mix in person and that, but let me get her on here just to kind of get it resolved, I guess. How's that?
All right. That's
All right,
fine.
give me 1 second here. Okay.
Thanks, Judge.
All right. Okay, Mr. Church, can you hear me?
I can, Judge.
And I've got Miss Allen's right in court, right at the podium there. I've got her sitting right by the podium there. I guess, Mr. Church, if you want to start for me and give me your argument what we're doing, and then I'll hear from her.
Yes, Judge. So Miss Allen appeared on the first hearing in this matter, January 13th, 2026. It was adjourned 7 days for a first hearing. And the second hearing, January 2026. My recollection of that hearing was that she had sort of popped in and out of Zoom, but left before the hearing, and a default was granted. In circuit court, Your Honor, and I'll address the meritorious defense side first. So there was only a default set aside. My client is the current holder of the record deed. That deed and the affidavit of correction that followed that deed, both of those have been sent to the court. My position on the meritorious defense is that Miss Allen does not have a meritorious defense because only one default on the pleadings has been set aside. That deed is still good. In fact, if my client wanted to go obtain a mortgage on the property, he could do so. He's the sole, or she is the sole record owner. That's Miss Sykes. As far as good cause, Your Honor, I don't believe that Miss Allen has a good cause to set aside the default on the 120 hearing, especially considering the fact that she was here and then left. So for these reasons, Your Honor, I think that motion should be denied.
Okay. And
Mr. Judge
you
Hannibal.
guys speak up about the rate? Yeah, there you go.
Okay.
That's good.
Judge Hannibal said he found cause for good merit even in the deed. I put my 401k down on the property as the owner because of their lawsuit, in a default lawsuit that they're trying to obtain the property. But he said I can obtain a lawyer to fight that, but he had put it in all of it, from my understanding, as to set aside. And I'd like that opportunity. He gave me some time to find an attorney, and I told him I had talked to one that would be the attorney, and he could fight probably both cases or all the cases pertaining to these 4 people.
Okay, and just so I understand though, the matter that was before Judge Hannibal was the plaintiffs were George Colston, George Grundy, Carolyn Grundy, and George Colston.
Carrie Sykes, I think.
She's not on here.
Okay,
Is that right, Mr. Church? The copy I got from, she gave me a true copy from Circuit Court. It doesn't list Carrie Sykes even on this.
She's the primary because all these other people are on the case with them, so.
I guess, Mr. Church, is she even on this case, this one?
She is, Your Honor. I believe there was a defunct entity situation, so she ended up as a plaintiff in that circuit court case as well.
Okay, so she's on that one as well. I guess we just leave it at that for later.
All of this is stemming from that case, the
Okay.
circuit.
But what Mr. Church is telling me, that the actual property, the legal owner of the property right now is Carrie Sykes. Is that
Well,
right?
that was from a default judgment, and that's what he was setting aside.
It's from a default judgment.
Yes, all of those are from a default judgment. That's what he explained to me in the court, that he said you're starting from 0, so all of it's set aside. And he typed this up. He said he found good cause of meritorious defense, and he granted it.
Well, I know what you provided me was, but.
Right, but
it's just,
he said this is the property. This is what he was pertaining to. Do I need to get clarification so that it's.
well, no, Mr. Church is acknowledging that Carrie Sykes might very well be on this as well.
Right,
And so, Mr. Church, help me out. How can if her claim is still, Donna Allen's claim is still going with circuit court,
yeah.
how, I guess, how am I making a decision on this if she's claiming she's an owner of the property, I guess?
Well, Judge, there's nothing pending in circuit court at the moment. So she's said that she's going to try to file a complaint to essentially, it sounds like quiet title, but there's no motions pending in front of circuit court. My client has a good deed of the property, Your Honor. But even if, assuming that she does have a meritorious defense, I still think that she needs to show good cause for the default on January 20th.
Yeah.
I was here on the 20th. I was here from the 13th to 20th, And I even came in here and talked to him
Well, the
all
last,
3 days.
just so that I understand, on January 27th is the date that I adjourned it to.
Yes, you adjourned, you told me you adjourned it to the 27th.
Oh, I was going to, but I did not. Oh, here it is. Mr. Church, I do have a note on the file that says defendant was sitting outside in court, was on Zoom as well.
Just like what
Hold
happened.
on, let me just read my note. No response, down at the screen. And I think actually that's where you were on the screen and I said, well, we'll just take a default at that point. Is that right? Is that what it was?
Yes, Your Honor. I guess I don't know anything about her sitting outside the courtroom, but I do have in my records that we have a default from January 20th.
And I think, honestly, you probably don't because this is where I should have done something different. I think that part of the note was after the fact. She came in afterwards and she was sitting outside. So for whatever that's worth, I should have made a little time schedule, I guess. I don't know.
I came into the court and saw you and sat out, just like today, I came in,
Yeah.
sat out there, the Zoom blinked out.
Okay. My staff's telling me that she was here too, apparently all morning, I guess. I tell you what, I'm gonna put this in it's gonna be a problem for me later on, but I'll set aside the default just to give you, in all fairness, okay? Well, I don't know if that's really gonna help you, but we're back at square one on that part.
Okay, because from my understanding with the judge, they're setting aside the quiet title because I'm still the owner. And so he said he was going to give me time to get a lawyer so that he can fight all of this stuff that's going on. I was in an accident and had head, neck, and back and ankle injury. So he allowed me time to get this magistrate at the circuit court so that I've been paying the taxes and doing all of this stuff. And so all of this was from the circuit court though, Your Honor. And
When are you getting an attorney then?
Okay, the attorney said 45 days. His dad was sick and he said it would be at least 45 days before his dad came back, and so he's kind of catching up, so he said at least 45 days.
I don't think Mr. Church isn't gonna like me going out that long either. What, Mr. Church, is it, not knowing what's going on at circuit with the issues, is it truly something that kind of comes into effect with this issue? If whatever happens at circuit will impact this?
But potentially, yes, Judge. And that being the case, if you're going to set aside the default, that's fine. I think that a motion for reconsideration on the default entered in circuit yesterday is going to be pending shortly, and maybe that'll clear this up.
Okay, so let's do that. When do you anticipate that happening?
I think that we filed it yesterday, so probably within the month.
Okay, if I don't want to keep coming back for no reason right now, I guess. Can we do it after 30 days then? Does that make sense? Set it for after 30?
Can we have at least the 45 like the lawyer?
Well, the
He
45,
needed,
yeah, sure.
okay, so at least 2 months. By the time he filed everything and get it, because it is, all of this, Your Honor, is based on a lawsuit where they're trying to take the house as,
I can go up, Mr. Church, on your schedule, if I give you, like, if we're thinking 30 days out, that does get us in, like, the beginning of March. Does that make sense?
Yeah, that's fine, Judge.
we have till April, sir.
I mean, I can't keep going out too much. You're gonna have to tell me, listen, get somebody on staff to help or something, okay? Because that's a long time. This has been sitting around since January now. Me?
Judge, if the motion for reconsideration is not heard by that time, I can either just file a dismissal or file another adjournment.
Okay, all right, let's do that. Man, we'll leave it on for this next day, March.
30 days.
Yeah, beginning of March. What is it? 10th? It comes out to March 10th, so it's almost close anyways. We'll leave it on for hearing for March 10th.
And this hearing is for,
For this eviction thing, termination. Okay?
okay,
Make sure you tell your attorney that they've got to move along on theirs, okay?
okay, well, he told me 45 days.
Yeah, and it might be, but if it's not gonna work out, Mr. Church is likely gonna do something else on this.
Okay, and so with the circuit court determination on this could,
Well, I can't tell you that.
Okay.
I don't have any of the issues. I don't know what
Okay.
it is. But Mr. Church is being upfront with me saying there is an overlap in theory.
yeah, the
So,
others is from.
okay. All right, so we'll leave it on for March 10th at 8:30. And Mr. Church, since you're I guess the attorney that's showing up here, if you could let us know if you need whatever, an adjournment or whatever we need, to just call us, okay?
Will do, Your Honor. Thank you.
Yeah. And then we'll send you a notice too for that date, okay? That March 10th date, okay?
Okay, and
But keep up with your attorney over on the other end there.
Judge, I think we lost you.
Yeah. I just turned it off because it wasn't worth on here. She's gonna get some directions with dates and stuff, so that's all that is.
okay,
Okay, ma'am? So we'll send you that too. Just keep up with your attorney though, okay?
okay.
All right.
Do I need anything? You're all set. Okay, thank you.
You're welcome, ma'am. Can you get out of there?
Yes, sir, thank you. You have a blessed day.
All right, you're welcome. Good luck.
Yes.
Mr. Church, I appreciate the patience on your end too.
It's no problem, Judge. Thank you.
This has been going on for a while, Judge. There was a federal court lawsuit regarding this property in which my client was successful, and he's looking to get his property back. So that's why we're here today.
And we just filed an answer today, Your Honor. The property, when the notice to quit was sent in March 31st of 2025, he didn't have rightful ownership of that property at the time.
That's not correct.
The federal court issued an order January 1st of 2020 or January 8th of 2026, where the property was actually awarded to Mr. Kowalski's client. And
I can give you the time frame that's accurate because that's just untrue. What happened was in March of last year, my client issued a notice to quit on March 31st, 2025. Subsequently thereafter, a deed that we alleged in our complaint that was not ruled on that action, that was stolen, and a police report was filed, was therefore subsequently recorded after the notice to quit was filed on April the 7th, 2025. So when the notice to quit was issued, according to the Genesee County Register of Deeds, my client was the landowner and title holder of the property. Therefore, as we sit here today, and after the federal court has ruled that my client voided the deed that Mr. Hatch subsequently recorded on April 7th, 2025, has been voided and is of no further effect. Pursuant to Judge Applebaum's ruling, the notice to quit was properly served. The federal court has ruled that my client has the sole ownership of the property, and we're in a position now where we would ask this court for a judgment of possession and a writ date of the February 20th.
Mr. Strip Matter, help me out a bit from your side then. What he's telling me, there was a notice to quit while he had whatever happened at federal court gave him authority to issue the notice to quit. If I do a short version of it, is that right, Mr. Kowalski? Is that right?
Yeah, before there was a recorded deed from Mr. Cameron Hatch that was recorded, my client had previously issued the notice to quit. The deed was recorded April 7th. My client's notice to quit was mailed and posted on March 31st.
Your Honor, that aside,
Go ahead.
if the notice to quit, that being aside, the judge ordered rightful ownership to his client. If we were to set this further out, or provide us 30 days, he's been in the house for 10 years, so providing some extra time to make arrangements, would be
just to move
helpful.
out. Okay.
My
I'm
my
just,
client's issue is he's been there, he's known about this. This
yeah.
Judge Applebaum ruled. He knew he was going to have to leave. He's concerned of damage. He's concerned of insurance issues. This is a family dispute that's been ongoing for over a year. And he's concerned about the condition of the property. We have an order from the bankruptcy court that we have to sell this property within 60 days of January 8th. The longer it takes to get Mr. Cameron Hatch out of the property, the issues we have then with the federal court, and we don't want that. So we need to get this moving expeditiously.
Is it a single family?
And
Right,
we
I'm
have no
sorry,
problem
Ken.
helping with that, getting him out expeditiously. Just additional time, and we could, give some assurances in writing as to the condition of the property between now and him exiting.
Okay, if I guess my concern kind of raises a little red flag is that if there's an order that it's got to be sold within 60 days, is that what it
Yes.
is?
Correct.
Okay.
I believe.
That's the hang up I got. When how much time really? I know Mr. Sturman, it's easier to say 30 days, but is he got a whole family there, or what's the deal?
No.
No.
I'm not 100%. Cameron, are you on Zoom?
Yes, yes,
Are you living at the house with your family?
yes. We have a minor child there.
Just one minor child. How old's your child?
He's 14.
Okay.
We're just asking for 30 days. We've been making arrangements for new housing. It's just taking a little bit longer than we expected, but we have been making arrangements. We're not going to damage the house. We want this to be resolved as well. We're ready to be moved on. It's taken a little bit longer than we thought to get into this other house.
But you think you'd be able to do that in the next 30 days, Mr. Hatch?
Yes, sir. Yes, sir.
Mr. Kowalski, I understand you want to just get it done and over with too. Can you give him a little more time than the statutory 10-day period?
And
If I-
my client told me that, he really needs to get this moving. I mean,
Yeah.
I don't have authority. I mean, I understand the
Okay.
position, but my client said, go to court and get a writ in the 10-day.
Yeah, sure. And I
Don't
don't
have-
want to put you in a spot either. I'll just
I-
make a decision. Yeah, I don't want to put you in a spot.
I'm already in a position where it's going to be tight to get this place listed and up for sale.
Yeah.
Mr. Mooney did talk to the trustee and made her aware of that, and she acted like it wasn't an issue if we needed a little bit more time.
All right. Here's
I
what
wasn't
I'm-
privy to those conversations, and it wasn't, I had a discussion with Mr. Mooney last night. I told him basically what I've told you, Your Honor, that I've got marching orders and they are what they are.
When was the? I'm sorry, I didn't mean to cut you off, but when was the federal court decision? When did that
January
happen?
8th.
And the order or the ruling from Judge Applebaum says plaintiff shall file a motion to sell the property within 60 days from the date of this opinion and order. So
Correct. And that was issued January 1st.
Okay.
Or I'm sorry, January 8th. My fault.
January, say, yeah. Okay.
And that's my problem here. I mean,
Yeah.
we've given time. We've given extra time. They had the whole month of January.
We've been making arrangements. It's just taking a little bit longer than we expected.
Here, I guess this is what I'm gonna do, put everybody out of their misery kind of. I'm gonna give a little extra time. Now, given the fact that we had federal court decisions coming down, what do you, I guess before I say that, Mr. Hatch, Cameron,
Yes, sir.
what do you have to move out? Do you have a
It's
house
not
with-
that, no, we have pretty much everything boxed up. It's the house that we're moving into
Okay.
We're still trying to work that out right now. I mean, it's so close, but we haven't had a official date for the closing, basically.
Oh, I see. So you're waiting for a closing date? Is that what's
Ye-
going on?
Yes, sir.
But are you all set to close? You just need the date?
We're pretty close. Yes. Yes.
Okay. All right. I'll grant 20 days. That gives you double what I normally would for it. So it'd be 20 days from today. Gives you till the actually gives you up till March, what, March 1st? Actually, March 2nd. We'll do March 2nd. Okay.
Thank you, Your Honor.
Thank you,
All right.
Judge.
All right, guys.
Thanks, Judge.
All right, and somebody get an order for me, I guess. Mr. Cross,
Yep.
is it you?
Yep, I'll
Okay.
get you in order.
All
Thank you.
right, thanks.
Thank you.
All right, thanks, guys.
Yep.
Bye.
Bye.
Bye. Ms. Franken, do you want to talk to him in private for a minute? Maybe we can get something worked out?
I don't think there's anything to be worked out.
No? Okay.
No, sir.
All right, we'll just proceed with the motion then.
Thank
Okay, let's start. Go ahead.
you, Your Honor. This is our unopposed motion for summary disposition. Any response would have had to be filed a week ago. Your Honor, in short, we filed a complaint for breach of contract and account stated pursuant to MCL 600-2145, along with an affidavit of account stated, along with her answer. The defendant was required to file a counter affidavit, if any. Without a counter affidavit being filed, Your Honor, that established our prima facie case. Your Honor, we filed this motion based on that and MCR 2116C9 and C10. This motion is unopposed, Your Honor. We therefore request judgment for the full amount, $3603.58 plus court costs comes to a total of $3,800.37. We've attached a proposed judgment as Exhibit G, Your Honor. And in summary, it's a landlord suing a former tenant principally for property damage.
Okay. Ms. Franca, anything you want to tell me?
Yes, Your Honor. Actually, I was a little confused when I received the first letter requesting funds from Spring Grove. I moved out of the property in April of 2023 with the approval of on-site management due to financial hardship. I did break the lease a few months early, but the on-site management was in agreement with that. So when I left the property on April 27th of 2023, I turned in my keys to on-site management. They wished me good luck. And that's the last I heard from anybody associated with Spring Grove until just a few months ago. So I'm not entirely sure where the monies is coming from. There were no damages to the property. My rent was paid. They did withhold the security deposit in full, which I expected because I did break the lease early. But I also have firsthand knowledge that the home that I was renting, everything was paid in full, and they also had new tenants residing in my former home within 6 weeks of my moving out. And I know that because I had friends in the neighborhood, so I was still visiting. So I'm just unclear what the $3,600 is supposed to be for.
No, ma'am, the unfortunate thing, you didn't file an affidavit for this motion today either. I've got nothing from you. So what the council is telling me is that it's uncontested based upon the court rules. With a motion for summary disposition, I gotta follow the court rules for everybody. Under this type of motion, you can't just rest on your laurels. You have to file something supporting what you're arguing. And what you're arguing is something factually, and I don't have an affidavit. I don't have anything from you right now. They've alleged in their motion, I guess you just saw it.
Your Honor, it's attached as Exhibit B. We've attached a statement. It's property damage.
There it
It's
is.
detrashing the home. It's painting, priming, and painting, and it's replacing a storm damage door. She left the place a mess, and they had to fix it before they could relet it. So they're not suing for rent. They're suing for a little bit of water damage, water charges, but that's all.
Yeah, if that's what I had tagged it earlier. It is the exhibit as well. It's they're charging for water charges on April 25th, May 15th. Those are nominal compared to the rest. Asked for turn cost damages, detrash a home, $250, which looks reasonable. And then based upon what they've alleged as damages, took paint prime and painting all interior and to replace the storm door. That's where those damages come from. They
Your
did,
Honor, may I speak to that?
you can.
The water charges, I'm not in dispute of. The storm door was damaged. It was supposed to be replaced by maintenance before I moved out. It didn't happen, but the biggest issue I have is $4,100 for repainting the interiors of the home. I lived in the home for 5 years. I moved in September of 2018. Also on that fact, my home was a customized home, so 90% of the interiors was in specialized wallpaper to give the aesthetic of a farmhouse. So there weren't even that many walls that were not wallpapered.
Okay. And that's the problem you run into when you don't.
I couldn't afford an attorney. I don't know what I'm supposed to do. I mean,
Yeah,
this amount of
I
money would
understand.
be an extreme hardship to me. I don't have it.
Okay. And I'm looking at the supportive evidence for damages.
Your Honor, I'll add for one, the lease is a
Sure.
22 lease. So it's not a 5-year lease we're talking about. It's a 1-year lease is the operative lease. Whatever she claims to have lived in the property in the past is almost a separate issue. But again, she didn't respond to any of this. And there's a prima facie showing, which it's too late for her to contest,
Yeah,
Your Honor, respectfully.
Sure. Yep, and I understand that argument too. I actually just found it. Affidavit of account stated as well in the file. There is enough supporting evidence based upon it. MCR 2.116 C9 and C10. I did take both into account. The C9 motion, there was a complaint filed objecting to the complaint itself and the answer filed, I mean. But based upon MCR 2.116 C10 and all the attached documents, we do find no genuine issue of material fact based upon the motion. Grant motion for summary disposition based upon a C10 motion.
Thank you, Your Honor.
Stated.
An order and judgment are attached as Exhibit G, Your Honor.
Thank you. I was just looking for it. Yep. Looks like it's in order. Damages plus reasonable costs of $121.79, statutory $75 attorney fee for a total of $3,800.37. It's granted. Okay.
Thank you, Your Honor.
You're welcome. Good luck to you, ma'am. This is adjourned a couple of times.
Yes, Your Honor, we were here last week. There was an issue with her recertification. I confirmed that her rental rate has been adjusted. So the balance due now is rent of $1,519, court costs $169 for a total of $1,688. So I confirmed that her rental rate did switch effective December, as she stated last week.
Okay. Miss Morgan,
Yes.
anything you want to tell me?
So the current rent that they're stating for me to pay is like 1,500 and something. That's my balance. So would that be for November? Like what is that? What is that amount for November? Because my current rent was 874, and like I said, I applied for Section 8 again right after I lost my job after the 2nd of October.
Right. So the 1688 that's due now would be what was due in the fall. And then your rental rate changed for the months that
So in the fall, when, ma'am?
November, it looks like, and December. And then they removed $2,622 off your rental ledger on February 4th.
Okay, so my current balance, when did they put the Section 8 in for December? What date was that? Because if I was already in the process of it, so that means I still have to recover for November and December?
Correct. And then it would be effective going forward for January, February, and continuing until it changes.
For the 874?
No.
Oh, okay,
You're
182.
adjusted.
Well,
You're
well,
adjusted.
and then they had made a different adjustment as well, just recently because they did some type of uh consumers cut or something like that. So they upped everyone's rent. So they just did another adjustment on it. So I did speak with Tina, and she said once we left for today, and she would try to work with me with payment adjustments because that is, a high amount. And like I said, I stated that I lost my job in October. And usually, if it did ever come to this, you normally would just pay the full amount, and they never had a problem with me doing that. But at the time, I cannot just at the moment. I did apply for rental assistance, and they denied me because they said that if I can't pay the rent now, then what is the point of them paying the rent for me now? And if I can't pay it moving forward. And then that's when I had to turn in paperwork stating that I did get an adjustment for my rent. And I showed them all of that. And someone did give me a call yesterday, to review my case. So, and I was eligible for, the SCR, but like I said, they said they wouldn't pay it if I wouldn't be able to pay it in the future. So
Right.
hopefully they will pay it. It sounds like I will be eligible. So I'm just basically waiting on them to give me a call back.
Okay. Judge, I would request entry of a possession judgment today. It sounds like she's already working with the property manager. They could make separate arrangements outside of court. It also sounds like she's working with a caseworker, so if a judgment enters, she could provide a copy of that.
Pam, does that make sense? We'll do that. Ms. Morgan?
Yes, that's fine.
Okay. All right. It's winner is possession only. By hearing.
Thank you, Judge.
I'm sorry. So does that mean like I will have it extended to a certain date, or just like what does that mean?
Well, right now you would have until the 20th, but if you're already
Okay.
talking at the property, I would just
Yes.
I would stay in touch with her.
Okay. Thank you.
Right.